And welcome to the Aaron Katzman Show. I'm your host, Aaron Katzman. We're here to speak to you about your life, your money, and your investments. And as always, we're coming to you for the spiritual and soon-to-be financial capital of the world, Jerusalem, Israel. If you've got any questions or comments, feel free to email me at Aaron, A-A-R-O-N, at lighthouse with an L, lighthousecapital.co.il. That's Aaron at lighthousecapital.co.il. You can check me out on the web at www.aaronkatzman.com. That's www.aaronkatzman.com. You can find me on Twitter, and be sure to subscribe to the brand new YouTube channel at Aaron Katzman. So it is my honor to introduce Osher Felicia Seaton, who is a U.S. International estate planning and tax lawyer. She's been practicing U.S. estate planning law and probate since 1996. She founded her U.S. estate planning firm in Israel a while back already, by time flies. In August of 2007, she practices U.S. International estate planning and individual tax, U.S. probate and estate administration, and tax and renunciation of U.S. citizenship and relinquishment of U.S. green cards. Welcome to the show, Osher Felicia Seaton.
Thanks so much for having me, Aaron. If I could just give Aaron a plug here and say that he takes care of my clients like no one else does. It is such a pleasure to work with his office. My clients are extremely happy, and there's no one who can top his integrity.
There you go. Well, then the wire transfer will be coming to you right now. I'm going to hit enter, and there it goes. Thank you very much. So let's just jump right in. We were talking before we went on about some really interesting issues that most investors, I would say, who have U.S. brokerage accounts, who live outside of the United States, it's not necessarily just Israel, but everywhere, don't know. And it's something that sort of snuck up on people over the last couple of years, and it's causing all kinds of problems. And that is like this. I'm going to phrase the question so like this. All of my accounts in the United States are titled with joint rights of survivorship. They're joint accounts with rights of survivorship. That should be fantastic, right? That should be totally covered. God forbid if one of the account holders dies, right? If one of the spouses dies, I should be covered completely. True or false?
So in some ways you are. That's absolutely true. All you need to wait for is a death certificate upon death. And then you submit that to the U.S. financial institution. You fill out some paperwork. Sometimes they'll need some notarizations. They might need something called a medallion signature guarantee, but all these are doable. And theoretically, within a few weeks to tops a few months, you should have access to the account. However, unfortunately, in the last 5 years, we've been seeing the U.S. financial institutions become more and more compliant with a certain little tiny section of the U.S. tax code, which is that the U.S. Financial institutions are required to require you actually to obtain something called a transfer certificate from the IRS. Essentially, that certificate states that your estate does not owe any estate tax, or if there was estate tax owed, that it was paid. And so it's kind of a stamp from the IRS that everything's okay and that the U.S. financial institution can transfer the money. So what's the problem, right? Okay, so you say, fine, I need something from the IRS, I'll get it. Well, before the last 9 months of dealing with COVID-19, the IRS was backlogged on these requests by about a year, 11 months or so, okay? And so anyone who hadn't received their transfer certificate by March of 2020 had been waiting about 11 months and now has been waiting since then. No transfer certificates that I know of, at least, have been released in the last 9 months. Wow. Perhaps here and there, but they're still catching up. I have one that I submitted 2 years ago, 2018, for a client. Wow. Now, you say, okay, so we have to wait for the transfer certificate. Fine, but meanwhile, the joint owner can use the account, right? I'm sorry, I'm asking all the questions.
No, that's fine. So let's get into that. Let's get into that because I'm going to lead in, but I'm going to say that there are certain firms, we were just speaking about this, certain firms that a joint account with rights of survivorship will allow the surviving spouse to still withdraw money based on living needs. But our firm does that. But as we were speaking, plenty of firms that you deal with don't do that. So talk about a little bit of that, and then maybe what are the solutions that you have to offer for people to have that, or for heirs or for the surviving spouse to have access to their money.
Exactly. And so what happens is, unfortunately, I've found this repeatedly at various U.S. financial institutions, and big ones at that, that they freeze the account as soon as they're notified of the death of one of the joint owners. So even though there's joint with right of survivorship and it should go smoothly, they take all the paperwork and then they say, no, the account is frozen. No deposits, no withdrawals. You can't also do any trading. And so everything just stays status quo until the transfer certificate is received. And again, the problem with that is you could be waiting a year or two for
Right.
that to happen from the date of the request. I will also note that the request is quite difficult. You have to report all of the decedents, the persons who passed away, all of their assets that they owned on date of death with date of death values. And so you don't have to prove them, but you have to be able to list them. And that can be a lot of work for people, especially if we own real estate or various
Right,
stocks.
and correct me if I'm wrong, but I think we've had cases where the IRS actually came back to the individual who submitted it and, asked for clarification, or there wasn't enough information. And then, we should all merit to live long enough to see that transfer certificate actually issued.
Exactly. And so that's the problem that my clients are running into these days, is they thought that everything was taken care of, but then unfortunately, one of them passes away. And in addition to having to deal with the grief of that, they also have to deal with the grief of this kind of bureaucracy. So what are the ways to get around it?
Right.
There are two ways to get around it. One way to get around it, if you're a U.S. citizen who's residing outside the U.S., if the decedent was a U.S. citizen residing outside the U.S., is to get a U.S., it's not really called a U.S. probate order, but to file for probate in the U.S. And as you mentioned earlier, to have a U.S. Resident executor appointed. And so if that happens, then you can bypass the need for the transfer certificate. However, I will say that that's time consuming, and also people often pay an attorney to do that who's local, especially if they're living abroad and they need someone. And you have to have an executor who resides in the States who's willing to serve. And some people don't have that anymore if they've been living abroad for a long time. So there are some downsides to that, but it's definitely doable. And then I have clients who say, well, you told me to avoid probate. And the entire web says to avoid probate in the US. And that's true. But if you're going to, weigh, let's wait a year or two for the IRS to get its act together versus I can get an executor appointed within a few months in the US, you might choose to do that.
Okay.
The other way to get around it is to have a US trust, what's called a living trust. And it's costly to set up. But then after it's set up, there are no additional costs to having the living trust.
There are no annual
And so,
fees or anything like that?
no, you can appoint family members to be trustees or trusted people that you trust to be trustees who aren't going to take compensation. And the trust now the one big issue here with the trust that everyone has to remember if they're going to set it up is fund it during life, which means don't just set up the trust and say, oh, everything will pass into it upon my death. Make sure that the trust owns everything that you own in the States that is non-retirement, okay, because you can't put retirement plans into trusts, and change the ownership. That shouldn't cost anything. It doesn't increase taxes. You don't have to pay capital gains tax on it. There's no fees from any of the brokerages or the banks to be able to change ownership. It's filling out a lot of paperwork, but it's a pretty simple task to do. And so that's the other option.
Okay, so those are the two options, either trying to probate in the US, which means appointing a US executor, or setting up a local trust. Okay, that's awesome. That's very interesting. I think that's information that we're in the business, so we know about that, but all the time this comes up and people don't know and they get surprised. And for all the viewers and listeners out there, do yourself a favor and listen to this advice, because it could save you literally years and lots of gray and white hairs and a lot of money, because it's not cheap to do all this stuff either, because you need to pay the professionals. How can people get in touch with you?
You can visit my website at www.ofm, Osher Felicia, and then my other middle name, -law.com. Feel free to email me at ofm at ofm-law.com. And I'd love to talk with you anytime.
Okay. So We are speaking with Osher Felicia Seaton, who is a practicing U.S. estate law and probate specialist. You're watching the Aaron Katzman Show. I'm your host, Aaron Katzman. We speak to you about your life, your money, and your investments. If you've got any questions or comments, feel free to email me at Aaron, A-A-R-O-N, at lighthouse with an L, lighthousecapital.co.il. That's Aaron at lighthousecapital.co.il. You can check me out on the web at www.aaronkatzman.com. You can find me on Twitter, and be sure to subscribe to our brand new YouTube channel where you can get all the interviews, all the content right there in one page on the internet. I know that's not the way you're supposed to say it, but I'm, it's not my generation. The YouTube thing is like, I'm a little old for the YouTube thing. Anyway, I want to go back to one thing that's important. We mentioned it in passing right at the beginning. We're going to get into another topic, but the issue of the transfer certificate, right? It has nothing to do with, it's nothing nefarious against Israel. It's if you're an American who lives anywhere, you could be living in Singapore, you could be living in Athens,
Dubai.
right? Dubai, right? That's the hot place right now. You can move to Dubai. It's going to come and get you, correct?
Yes.
Okay.
Yes, absolutely.
Okay, so that's important to note because I think a lot of people come to me and they say, "Oh, what do you mean? It's it's not anti-Semitic. It's nothing." That's the IRS's rule for anybody who lives outside, who passes an American citizen who passes away outside of the United States.
Exactly.
Okay, so the next issue for that I want to speak about is also an issue which is very common, and that's when you have a mixed marriage. Now, in local vernacular, a mixed marriage is when you have an American who gets married to an Israeli. And that can cause all kinds of estate plan issues as well. Can we sort of touch on them? Can you talk about some of the issues and some of the solutions?
Absolutely. So we have essentially two issues here. And unfortunately, I'm going to have to talk in the language of who dies first. And so I hope everyone will forgive me for having to talk like that. But basically, if you think about the flow of wealth, okay, if the U.S. citizen inherits everything from the non-U.S. citizen, and thereby has a wealth that's worth more than the exemption from the estate tax. Okay, the current exemption from U.S. federal estate tax is 11.58 million. It's going up in just a few weeks as of January 1. However, in 5 years from now, okay, 2025, it will go down to between 6 and 7 million. Okay, that's the current law. A lot of people are asking me right now if the law is going to change due to the new administration. There's really no talk so far of that changing.
Okay.
I personally would also be somewhat surprised if they did change it very much and lower it a lot, because in 2013, the exemption was raised to 5.5 million by a bipartisan bill under the Obama administration. So so it seems to me it's probably going to stay somewhere around the 6 or 7. It might increase annually for cost of living. In any case, if the U.S. citizen inherits everything that the couple has because they're second to die, they're the survivor, and then passes away owning more than the exemption amount, that needs to be planned for, because it's a simple plan actually. And what it does is there have to be, it's going to be strange to think about this, but there have to be two different wills, right? If the U.S. citizen, the U.S. citizen's will can leave everything to the non-U.S. citizen, because the non-U.S. citizen isn't going to be subject to U.S. estate tax, except for one situation, and that's the other example I'm going to give. But the non-U.S. citizen's will needs to specify a couple of things. There are a few options, and it depends on the family dynamics. One is to leave the U.S. citizen as much as whatever the exemption is at that time. So they can inherit, let's say, up to 6 or 7 million, so they have a nice net worth. And in addition, a trust can be formed for the benefit of the U.S. citizen that will give the U.S. citizen all of the income that the U.S. citizen needs during the year in order to, pay their bills, et cetera. That trust will most probably be a non-U.S. trust. And I'm not going to go into the differences right now. But if it is a non-U.S. trust, then the U.S. citizen needs to receive all of the income from the rest of the assets on an annual basis, okay? So as to avoid additional U.S. income tax. And so that's one scenario that we run into. Another scenario that we run into, I just want to add one with regard to that. Make sure that if a U.S. citizen is going to inherit companies, okay, significant shareholder interests in non-U.S. companies, that the family consults the appropriate CPAs and tax professionals, because if not, you might not want a U.S. citizen inheriting that type of interest, because there'll be additional U.S. tax.
Okay.
Okay.
So this scenario is when, again, this whole scenario where you can leave up to like $6 million and put the rest of it into trust. That's if the, in our case, the Israeli were to die first. Okay. And the surviving spouse is an American citizen.
Right.
Okay.
Right.
So now scenario number 2.
Right. And in that scenario number 1, we're talking about wealthy families, right? In scenario number 2, we're talking about any family. Okay. You don't have to have $6 or $7 million. And here's scenario number 2. Okay. What happens if the U.S. citizen passes away first and leaves everything to the non-U.S. citizen? Well, if the U.S. citizen owns U.S. assets, okay, so if the U.S. citizen owns some real estate in the United States, or the U.S. citizen owns a brokerage account with Aaron's firm, or whatever it is, an IRA, okay, retirement accounts in the U.S. The U.S. citizen inherited something from their family and now they own it, and then they're going to pass it on to their spouse, okay? And so if that is your scenario, we have to remember that the non-U.S. citizen is also subject to U.S. estate tax when they pass away. However, their exemption from U.S. estate tax is only $60,000.
Right. Not 6 million, ladies and gentlemen, $60,000. That's not a huge amount of money.
Right. And not per asset, but total. And so what happens is, if, God forbid, a non-U.S. citizen passes away, having inherited assets that are located in the United States, then all of those assets are tallied on their date of death. And if it's more than $60,000, then the U.S. estate tax is going to have to be paid on them. The U.S. estate tax is quite hefty. It's essentially a double tax because it's on what you own, not just what you earn on what you own. And it's 18% from the first penny above the exemption, which here is $60,000, and it quickly goes up to 40%.
Right.
Okay, and so and you have to pay it within 9 months of date of death, and so it's very, very important to plan for this. Aaron, do you want me to go into how to plan for that?
I would like you very much to go into how to. What's this? We'll say what's the solution. What is the solution to this problem? Because this is a very, very common problem. Very common problem.
So there are 2 solutions. One of them I don't like, so I'm going to leave that one for later. The other one is one that I do all the time, which is, once again, a trust. And I know that I sound like I'm selling trusts here, but really it's becoming the only vehicle that can solve a lot of our issues.
Okay.
This trust is a little bit different than the various trusts that I've mentioned during our talk today. This trust is a trust that only the U.S. citizen sets up. It's a U.S. trust. The U.S. citizen will essentially own all the U.S. assets until they pass away. And then the non-U.S. citizen cannot take over the trust. It'll have to be other U.S. citizens who take over the trust. So maybe adult children, maybe a sibling, maybe a niece or nephew, someone they trust. But the beneficiary will be the non-U.S. citizen. So the non-U.S. citizen can receive the benefits of whatever there is in the United States, can receive the dividends, can receive the interest, can receive the rental payments, can receive the IRA payments, et cetera, But when they pass away, the estate tax will not apply because they don't have any control over what those assets are.
And if they need a chunk of, what if they need like a chunk of the principal?
The trust can be written so that the trustee has the discretion, meaning the trustee can make a decision saying, oh, I noticed that the non-U.S. citizen spouse needs some money. Okay, here's some money.
Gotcha.
It can be that simple.
Okay.
Now, I will say another option, but this one is a little bit difficult for people often, is to wait until first death, God forbid, and then to sell everything and get out of the U.S. I will say that that's a costly option. Okay, often people own a nice amount of assets in the US, even if it's not their significant amount of assets. And when you sell it, let's remember that at least if you're an Israeli resident who sells it, there's no step up in basis, which means that there'll be a hefty capital gains tax if you
Right.
do sell it upon first death.
Okay.
Okay, so that could be an option, but it's not necessarily the one that many of my clients choose.
Okay. And just quickly, let's just, where you have two Israelis who are married to each other, you know, it's been popular. We have it, right? We have Israeli clients who open brokerage accounts in the States. A lot of Israelis flock to U.S. real estate. That's very trendy. They should be very, very careful, correct?
Very careful.
I mean, they're really sort of up the creek. If something happens to one of them, they're really, really stuck. So I would assume that, you know, your solution here would be almost only either setting up a company or a trust in order to avoid estate tax issues.
Right. If they're young enough, then they can consider some life insurance. That, of course, doesn't actually solve the problem, but it enables them to replenish the money that would have been there. That's not an option that a lot of my clients enjoy because there's a premium involved, and so they have to pay for it. I will say that it's a very dangerous situation, Aaron. I'm just going to add one thing that most people don't know. It can be double taxed. In other words, you can pay a full 100% estate tax on the entire account, even though it's joint with right of survivorship, okay? Especially because it's joint with right of survivorship. There's a special, again, this tiny little US tax code section that says if it's joint with right of survivorship and the survivor is a non-US citizen, the first to die will be taxed on the entire amount. Then the non-US citizen surviving spouse inherits it. And if they don't move it out of the States, they're taxed on the entire amount again, unless they pass away within a few years.
Wow.
And so it is a dangerous situation.
Wow.
Yeah.
How can people get in touch with you?
Wonderful. You can visit me at my website at www.ofm-law.com. Thank you.
That was great. This was really good. And I think I'll bring you back because I want to talk about renunciation of citizenship, which is also a big, big issue. We'll do that another time. Thank you so much for joining us.
Thank you for having me.
My pleasure. It's been the Aaron Katzman Show. I'm your host, Aaron Katzman, where we speak to you about your life, your money, and your investments. If you've got any questions or comments, feel free to email me at Aaron, AARON, at lighthousecapital.co.il. That's Aaron at lighthousecapital.co.il. You can check me out on the web at www.aaronkatzman.com, www.aaronkatzman.com. You can check me out on Twitter, and be sure to subscribe to our brand new YouTube channel. Thanks so much for watching, and we'll see you soon.